This is the IEBC's own document. We're asking that you open on your own devices, but even as we show, Murang'a County. Kangema, Mogoro, and Gasharaigo. My lords and my ladies, we have downloaded a Form 34A from the IEBC portal. And I'd like the court to just scrutinize this form before we go to other details. From where I am, the stamp. The stamp. My lords and my ladies, is that the IEBC stamp? It's on the IEBC portal, looking like it's been superimposed over another stamp. We have been asked to show how are the figures changed. The votes. Now, my lords and my ladies, if we look at the votes cast, the first figure on the form is for Raila Odinga, 55. It's followed by William Ruto, 260. It's followed by, I think that's Mwaure Waiga, 001. And the last is Wajakoya, 000. If we sum up the total votes, we get 316. The total votes cast according to this particular form is 321, different from what we have just seen. The rejected votes are 4, which means already by calculation there is a problem. But we'd like the court to look at the total number of registered voters. A close scrutiny of the form shows that the number was probably 455, and the 5 is actually similar to the figures written in the votes cast. But somebody or somehow that figure has been changed to make it look like 488. It is obvious to the naked eye when you look at that form. Now, when we go to now the bombshell itself, the top left-hand corner of the form, we were told by my colleague, Mr. Gumbo, there were no foreigners in this election. We were told the foreigners left before the 8th of August. We were told they did not even have access to maintain the server. This is on the 9th of August, and at the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country. It is on the IEBC portal. It is live. How did that come there? What are you doing? This person is the one who was interfering with the forms. we are able to demonstrate, at least a crumb was left. By God's grace, we found something. We didn't make this up. We were told we forged these documents. Now, this is how, my lords, the staging was happening. This is how the changes were happening. This is on the 9th of August. We were told they were not there. I'm going to do, because of time,
with your permission, Your Ladyship.
I beg your pardon. In our petition,
You read our finish and then you tell us what it is. They're responding.
It relates to an objection to what she's doing, Your Ladyship.
No, let her finish.
And it's not the IEBC.
my ladies, my lords, that name, Jose Camargo Gregorio, appears in our petition and is also, that evidence is also found in the affidavit of the second petitioner, one of the people whom we complained about as having interfered in the election and who were told had no access. My lady, we're going to take you again on the same IEBC live portal to show how the staging was happened. And because of time, if we can go to Bungoma.
The Wapanim, Manim, Pungamare, Selana in the Makalakuna.
ഇതങ്ങനെ പാർട്ടിക്കാരടപെട്ട് തീരേണ്ട കാര്യമൊന്നുമില്ല.
തുക്കോയാ ഈ ഹിമാറിനോട് പറഞ്ഞു കൊടുക്ക് ഞാൻ ആരാന്നല്ല ഇവിടുത്തെ പാർട്ടി എന്താന്ന്.
എന്തായത്
ഗുണ്ടായിസല്ല കമ്മ്യൂണിസാ.
കൂട്ടുകാരനല്ലപ്പാ കൂടെ പറപ്പാ നമ്മള് വെറും കാറ്ററിംഗുകാരല്ല പാർട്ടിക്കാരാന്ന്.
ഈ കേസും എന്താവുന്ന എനിക്ക് നന്നായി അറിയാം. റിമാൻഡ് പീരിയഡ് കഴിയുമ്പോഴത്തേക്കും ഇവനൊക്കെ സ്മൂത്തായി പുറത്തിറങ്ങി.
രാഷ്ട്രീയ പ്രവർത്തകൻ
ഒരാളെങ്കിലും എനിക്ക് വേണം.
ഈ ഒളിച്ചോട്ടം കൊണ്ടൊന്നും നിൽക്കൂല. കരുതി ഇല്ലാണ്ട് കുറെ പായേണ്ടി വരും. പായണ്ടേ? എനിക്ക് പേടിയുണ്ട.
തീർക്കുന്നെങ്കിൽ ഒരു തീർക്കട്ടെ സാറാ, എനക്ക് പേടിയൊന്നുമില്ല.
ഇവിടുത്തെ കുഞ്ഞുങ്ങ സിനിമാ പാട്ട് കേട്ടല്ല വളരുന്നു, ഇൻകുലാബ് സിന്ദാബാദ് കേട്ടത്.
ഞാൻ പോറ്റിയതും വളർത്തിയതൊന്നും എൻ്റെ ഉമ്മ ഉപ്പല്ല, എൻ്റെ പാർട്ടിയാന്ന്. അതുകൊണ്ട് തന്നെ ഏടെ ഇൻകുലാബ് കേട്ടാലും ഞാൻ സിന്ദാബാദ് വിളിക്കും.
Nimekaa Presidential kufanyiwa feeling, kuoshwa meno, imekuwa poa. Nilikuwa nadhani ni uchungu, lakini iko sawa, na recommend wasee pale mtaani wakama Presidential cause ni palipopoa. Dentals wanafanya yani kazi yao fiti na ni poa. Juu unaenda mtaani meno yako kiwa healthy, una nice hadi smile manzee, jo unapiga pia.
We want to do it live, and we're doing it live on the IEBC portal. My lady, we were told about the KIMS kit and how they work. The serialization of the numbers. We have been told that each of the 42,201 KIMS kits that were used in the election had their own unique KIMS kit ID and serial numbers. Bungoma County, Mount Elgon, Chesikaki, and Songoyiwa. We'll download the form. The nomenclature of the KIMS kit and the form is shown at the top on the address bar. And for purposes of time, my lady, what we're told, it will show you that that's a Form 34A. It will give you the serial code of the polling station from which that Form 34A relates. And then it will show you the KIMS kit serial number or ID. There'll be a date stamp and a time stamp. What I'd like the court to focus on is the serial number, and perhaps because I can't see from here, this is where I would have liked the court to have its own, but maybe if it can be. Do you have a roving mic? Now, the serial number on this particular form, my ladies and my lords, which I would have liked for the court to confirm for itself. If somebody there can, may I ask one of the court assistants to read for us the serial number as it is, so that then I'm not accused of making up things.
That's all right. It doesn't change anything. Evelyn, could you read that?
The number that starts with F2, it's in the middle. Or can I read it myself? Yes.
I can't see it. The one on top.
Yes.
PR06.
No. The one.
Oh, sorry. F2.
My ladies and my lords, what would require is that you note down that number. We will compare it with another later.
It reads F2 3045 0M 00204 133.
The time, please. It's right next on the date.
That one. The time is
the date on which
9th August 2022 at 1956.
We'll check another form. Nyeri? Nyeri Town? Gatitu? Morogoro? Tunguma Primary School? Stream 3. Kindly read the serial number.
F230450 M00204133.
And the date and time, please.
9th August 2022 at 23:49.
My ladies and my lords, this is the same KIMS kit transmitting or sending results, one from Mount Elgon, 1,000 kilometers away from Nyeri town. 2 hours later, how is that possible? When each KIMS kit was supposed to have, each polling station had its own unique KIMS kit, which was supposed to transmit from its own unique IP address. Because of time, I cannot demonstrate the thousands of forms that we have identified with the same issue. My ladies and my lords, this is how the staging or the complaint that we raised happened. We did not give this court a fiction. What we gave the court happened. Now, staging, and as we have shown, the 11,000 polling stations that we had complained were staged were transmitted all from one IP address. Every KIMS kit was required to have its own unique IP address. The only way 11,000 KIMS kits or results can be transmitted from one IP address is if they were collected, and as probably my senior Paul Mwangi had. May I have, I beg your pardon, my time is up.
Yes, 2 minutes.
Yes. My ladies and my lords, the manner in which the election was stolen, the reason why staging was necessary was forms were intercepted like this. Whoever intercepted them then had time to decide which ones they could manipulate before uploading them and sending them to the IEBC portal. The other reason that we know there was manipulation is because the original Form 34A is a colored form that should have appeared at the National Tallying Center if transmitted in one transaction as a colored form. All the forms that are on the IEBC portal are in black and white. At what point were they altered from JPEG to PDF? When did that modification happen? And what other modification was done to the form? We submit to you that we have shown that not only was it possible, it did happen, and the fingerprints of those who interfered in the systems are still there. Thank you for your time. I don't know whether to be that generous. I donate the 29 seconds to the court. Thank you very much. At the insistence of my seniors.
May it please the court, my name is Kirago Kimani. My learned friend, Mr. Katua Kigen, had gotten the attention of the court, but was asked to wait until Ms. Soweto had completed her presentation. I would wish to respond to what she has just addressed you on, because this is new material, and would like to have directions.
Mr. Kirago?
Yes.
When I forget his name. Mahat was answering the questions. He did the same.
Yes.
He went through his PowerPoint.
That's correct.
To demonstrate.
That's correct.
How this staging was happening, because we asked that we be explained.
Yes.
How the forms were being captured in the hair and being changed. And he did that.
Yes.
Going back to what he had done.
Yes.
So what is new here?
What is different is this. You have a petitioner and you have rules that say how they are to present their case.
This was answering a question from court.
Yes. Where does the first respondent have an opportunity to address these matters? At what point in time does the first respondent get a hearing?
This was a question by the court to demonstrate how this was happening.
Yes.
What we do with the demonstration. Mr. Mahat on your side did demonstrate. They have demonstrated.
I appreciate what your ladyship is saying, but Mr. Mahat, with respect, is not on our side. He is a referee. My client, by the Constitution.
Mr.
But anyway, the long and short of
sorry.
it, yes.
I'm
the long
sorry.
and short, yes.
We are not going to give you time.
Much obliged.
Yes, thank you. Proceed with, there were responses from the other petitioners. What was next? It was, I think, Senior Counsel Jan Mohammed was her client. The same order we followed so that we don't waste time. If you can't use the 15 minutes, please.
Your Ladyship, Madam Deputy Chief Justice, my lady and my lords, I was very generous in my opening, so I'm sure I'm going to be just as generous and patriotic as I am in my rejoinder. I was the first one to donate 7 minutes in my opening.
Okay.
My lady, on behalf of the petitioner in number 1, that's the second petitioner, we had filed a rejoinder of the submissions after our original submissions. And my lady, the petitioner's case is very simple. All it was the petition was limited to a legal issue. It was the role of the commissioners vis-a-vis the chairperson.
I saw people murmuring, and I want to get this correct.
I'm sorry.
Is it that we should then, because I thought you had a response, you had any question to answer?
In fact, my lady, the question I'm going to be answering is actually the rejoinder as to the role, as the answer to the role.
For purposes of orderliness, because we are trying to get our proceedings as orderly as possible, then we can start with the rejoinder by the first petitioner, then the others will answer the questions with their rejoinder.
Because my actually rejoinder is the response to the question of what the role of the other commissioners was vis-a-vis the chairman and the commission. Okay. That's what my entire petition is based on.
So then we start with the main petition,
that's
their
fine.
Rejoinder, then we
That's
come
fine.
to you. I'm sorry about that.
That's no problem, my lady. I'll still donate my time.
Yes. Senior Counsel Orengo, it's your turn.
I'm just wondering, because if I heard the court correctly, there are some questions put to Mr. Mtata.
They will respond with their rejoinder.
With the rejoinder?
Yes.
Oh, okay, then that's correct. In our rejoinder, Madam Chief Justice and the members of the court will have 4 in our team giving the rejoinder. Senior Counsel Firoz Norji, Senior Counsel Otiende Amolo, and Senior Counsel Philip Murgor, and I'll have 5 minutes at the end. Okay. But I'll begin with Senior Counsel Otiende Amolo.
If it may please Your Ladyship, this Honorable Court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus 1. Your Ladyship, this Honorable Court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at that same time, in paragraph 21, that is Moses Sunkuli, says it was 56.17 at that same time, looking at the same Kim's kit. It will be noted by this Honorable Court that at various times, the IEBC gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which IEBC proceeds is wrong, and that the reason for this moving target is so as to manipulate the question voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, Your Ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The IEBC did publish a Gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Kim's kit, the figure they are seeking to use is 22,005,541. We wish to submit, Your Ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the Kim's kit, which ends up with a moving target. We wish to submit, Your Ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, and we will submit, we have submitted this for ease of reference, because Dr. Otumba covers is between paragraph 5 and paragraph 30, and puts all those graphs. By whichever permutation, none of the candidates then achieves 50% plus one. Whether you use, remove rejected votes, you add rejected votes, whatever permutation, and there are 7. We wish to submit, Your Ladyship, my lords, that you then need to come to the conclusion that even though they try to take time to tamper with the voter turnout, they do not achieve that target. The last point on that. Why is it wrong to use the vote turnout as per the so-called Kim's kit? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you were to rely on the Kim's kit, and all 42,298 Kim's kits failed, and only one in one polling station functioned, then it means that if the 700 voters in that polling station voted, the IEBC will be telling us that the voter turnout is 100%. That would be the logical consequence of that narration. That cannot be. The voter turnout cannot be something that depends on the interpretation of the IEBC at its convenience. It must be the denominator as a percentage of the total registered voters. My second point, my lords, my lady, and I do not want to go too much into this, the question of the infrastructure, what the IEBC called the impregnable military style infrastructure. I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, Your Ladyship, my lady, that the one question they failed to answer was why was there stoppage of the streaming of the results at Bomas? They have not answered that, because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, your ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IEBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, your ladyship, you are the Chief Justice and you are the president of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to, that you cannot override that decision by IEBC itself because it's made by the majority. I wish to stop there for now. Thank you, my lord.
My Lady Chief Justice, members of the court, I address the court firstly on the issue that in making your final decisions, in reviewing your own views, the views of the respondents, petitioners, parties who have addressed you, we would be praying for the prayers and orders that we have sought. And in doing this, may I first refer to the principle that would be applicable in approaching your decision and judgment. In this context, the court has heard today from my senior AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the commission should have an executive chairperson. That we have learned much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for the, even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions, or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the IEBC. The verification has to be done by the IEBC. The declaration decision has to be made by the IEBC. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki, in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, in great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor? No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity, justification of plain wrong. Is it, the issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, Unilateral Declaration of Independence, to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still recognize the usurpation of power. And they were hung, not only in Rhodesia, but in Pakistan. After a coup, their courts accepted that the doctrine of necessity, the acknowledgement of what was shown to be the new Grundnorm, would have to be acknowledged. And so the coup was all right. And so my learned friend, the professor, is saying, you too must acknowledge. And what does the doctrine of necessity always acknowledge? It acknowledges wrongful taking of power. And the Grundnorm is thereby changed, and therefore the court must accept it. So they're basically saying to you, recognize there was need, recognize that the chairperson did this out of necessity, and therefore it has to be accepted. It was done in Nazi Germany. That's where the Grundnorm comes from. And therefore, we submit not only that you should reject it, but you should condemn the attempted use of it so that it can be used here now in this innocuous, apparently innocuous moment in a case in a hall full of lawyers and judges. But